capital. An investor is asking for preference shares, and you're not entirely sure what that means. You've been handed a term sheet packed with things like liquidation preferences, anti-dilution clauses, and veto rights. And honestly, it's starting to feel a little overwhelming. You want to raise funds and bring in investment, but not at the cost of losing control of the business you've built. If that sounds familiar, you're in the right place. In this video, I'll walk you through what preference shares are, how they differ from ordinary shares, and what those terms in the fine print actually mean for you as a founder or as an investor. I'm Damon Murdoch, principal lawyer at Leo Lawyers. You might already know me, or maybe this is your first time here. And while this looks and sounds like me, what you're seeing is my AI avatar, delivering a script that I've written and personally approved. Now let's get into it, because in venture capital, control is everything. And I want to help you make sure you don't give away more than you realize. So what exactly are preference shares? Put simply, preference shares are a special class of shares that come with rights that are more favorable than ordinary shares. The exact terms can vary depending on the deal and even the country, but in Australia, there are a few standard features that show up regularly. First, these terms are typically set out in your company's constitution. That's where the definition of a preference share lies, along with the rights attached to them. One of the most common rights is the liquidation preference. That means if the company is ever liquidated, preference shareholders get paid back their original investment before anything goes to ordinary shareholders. For example, if a company shuts down, the liquidator, employees, secured creditors, and unsecured creditors are paid first. Whatever's left is distributed to shareholders. But if there are preference shares in play, those shareholders get their original investment back before anything is paid to ordinary shareholders. Next is the anti-dilution provision. Now, in Australia, this usually doesn't mean preference shareholders avoid dilution completely. What it typically means is the company can't issue new shares at a lower valuation than what those investors originally paid without compensating them. Let's say someone invested at a $4 million valuation. A year later, the company hasn't hit its targets and now wants to raise capital at a $3 million valuation. Under an anti-dilution clause, before those new shares can be issued, the company has to top up the original investor with bonus shares. That way, they're effectively brought down to the same $3 million valuation, so they're not penalized for investing earlier. You'll also often see veto rights tied to preference shares. These are written into the shareholders' agreement. They can change the definition of what counts as board resolution or a shareholder resolution so that certain decisions can't go ahead without the preference shareholders signing off. In some cases, they may also have the right to appoint a director to the board. And depending on the deal, preference shareholders might receive the same dividends as ordinary shareholders, or they might get different entitlements. They might have additional voting rights, or in some cases, no voting rights at all. These are all things that need to be reviewed closely. So what can founders do? If your investor is asking for preference shares, it's time to sit down and negotiate. You'll want to make sure the terms in both the Constitution and the shareholders agreement are fair. That might mean inserting founder rights into the shareholders agreement to give you a voice in key decisions, or you might push back on how certain preference rights are defined in the Constitution. Either way, don't sign anything, especially a term sheet, without getting proper legal advice. And if you haven't already, I recommend checking out our video on shareholders' agreements. It ties directly into this conversation and gives you the bigger picture of how founder protections and investor rights interact. Raising capital is a big step, and getting the structure right is critical. Whether you're dealing with preference shares, negotiating founder rights, or reviewing a term sheet, we're here to help you make informed, strategic decisions that protect what you've built. If you'd like tailored legal advice or support drafting your agreements, give us a call on our number in the description box or visit our website, leolawyers.com.au. At Leo Lawyers, we make sure your cap table works for you, not against you. Thanks for watching.